Counsel for plaintiffs, please.
Good morning, Your Honor. Michael Gayan from Kemp Jones for Plaintiff State of Nevada. Also with me is Joe Larita from my office. Also my co-counsel David Slade. And on the Zoom, it looks like we have from the state side, Brian McMath, Michaela Holweiler, Phil Carlson, Matt Bush, and Brian Moore.
Okay, on the meta side, please.
Good morning, Your Honor. Tammy, Peterson, on behalf of Meta, with me this morning is David Sneed, who's admitted pro bono DJ in this case, and also Dan Wick and Louis.
Anyone on Zoom that you need to interview?
We have nobody on Zoom for this case, Your Honor.
Oh, okay then. Okay, so welcome to today's hearing. Today's hearing was the stipulation or the continuation of the hearing relating to the proposed stipulation order for coordination/consolidation from the 529. And yes, the court received your 7-1 letter and then received your proposed order. And the court also had an opportunity to view, as in the proposed order, you referenced other orders in other departments, including Department 15 and 13. So the court took a look at those. So let me bless you. The short version is we're going to find a way to make work what you need to make work, okay, in accordance with the rules. Technically, the EDCR, and I see that as you rephased your proposed stipulation, the fact that it says the judge who has the lower case, right, infers there has to be more than one judge. It can't be my left hand and my right hand, right, okay, or my left brain and my right brain telling each other what to do, right? I mean, you don't have to have a reference to one judge if there's only one judge. But at the same time, the court has broad discretion, particularly under EDCR 1.61 for its case management to allow cases to move forward, and these are all business court cases. So short version is we're going to find a way to get done what needs to get done in accordance with the rules. Okay, so that now leads to the next step is how to get there. What the proposed stipulation appears to be requesting is that based on stipulations you had signed by Judge Hardy in a case and Judge Denton in another case, when I say another case, the Facebook, which was Judge Denton, which ends in 115, and the Instagram, which is Judge Hardy, ends in 120. You requested that certain hearings, should I pause for a second? Are we about to have another appearance? Did you wish to make an appearance, counsel? Or are you just observing? Okay, no worries. Okay, so based on those stipulations, it appears you don't have a date certain, but you have a conceptual idea of a date by which certain motions to dismiss would need to be filed, based on the phrasing of those, and a no sooner than for a hearing, okay? And then in this case, based on something signed by the department while I was out of jurisdiction, you have a date of September 6th, but there's no underlying dates certain for when oppositions and replies are due. You can appreciate we're going to fix that, right? Because I can appreciate as sophisticated lawyers, you might try and say that guess what that means, you can do things the day before. I know you would never do that. However, because the way you have triggered, you have a deposition takes place after certain productions, and then you have oppositions, then you have replies, but you don't have dates certain, and you have a reasonable time component with regards to the deposition. So my first question was going to be, maybe you all already have background information that's not in the document provided to the court that might actually have specific dates. If not, we're going to ensure that we have clear, concrete dates so that everyone can be fully prepared and everyone's on the same page as to what dates need to be done in order to get you where you need to be, and whether or not that still makes the September 6th date work. Counsel for plaintiff, you're standing up. Maybe you're going to enlighten me on some dates I don't yet know about.
Yes, Your Honor, Michael Gayan for the state. I want to make a few comments before I get to the date point, because I think there's some background here, and this will likely all sound familiar to the court. But we've been meeting, conferring with Meta's counsel, Mr. Sneed, and the whole cadre of folks over there for quite a while on the jurisdictional discovery, and that is kind of the contingent or predicate to setting the depositions. I believe we're on track with Meta's production on jurisdictional discovery, which is due next week, July 15th.
That was in your proposed tip.
And we had hoped for a bit of a rolling production to reduce the amount of time needed to review whatever we get on the last day, but that hasn't happened for whatever reason. And so we don't know the volume of documents we're going to get, but we did reach out yesterday asking Mr. Sneed and his co-counsel if they're on track with the production deadline, and also for the names of the witnesses for the depositions and some potential dates so we could get those in and work towards having a firm date, because we do want to set the briefing schedule, and the parties, I can't recall if it's in the stipulation that we submitted, proposed stipulation in order, but the goal with the Facebook and Instagram briefing schedules to have those fully briefed, and the opposition dates for the state in both of those cases was timed with the goal of having the messenger jurisdictional discovery done. What I mean by that is the documents produced and the depositions completed so that the messenger opposition has the benefit of all of that jurisdictional discovery, and the state can then also use that information with the Facebook and Instagram opposition briefs. And that's the goal with those briefing schedules and what we've been talking about. So we tried to address Your Honor's concern from last time that we're not doing this 3 times. The goal is that we do it once. We incorporate that information into all 3 opposition briefs for the state, and then have all of the briefing done around the same time. The state's proposal was to have a single joint hearing on all 3 motions because they are going to be very related, and I know the court hasn't likely looked at any of that yet, but from the discussions with Mr. Sneed and his co-counsel, we understand that all 3 motions to dismiss will largely raise the same issues. The state will be responding in largely the same way, and so there will be a lot of overlap. Meta has agreed to at least combine the Facebook and Instagram hearings. That's what I believe is in the stipulation that you have before you. And Meta's preference, the way I understand it, is to have a standalone messenger hearing and then a Facebook Instagram hearing. The state has agreed to that. Obviously, it's the court's discretion on what you want to do. The state had proposed a single hearing to reduce the burden and avoid overlap. But, in any event, I believe, and I don't want to speak for Meta, I'm sure Mr. Sneed will chime in, but I believe Meta's position is to have the messenger hearing first and then the Facebook Instagram hearing after that, subject to the court's agreement.
Okay, so pause for a quick second, because you made a statement, okay? The court has looked at everything available on the public record. I can't look at pending motions to dismiss that haven't yet been filed, folks. Okay, we keep referencing the beautiful crystal ball, right? But, okay. So yes, it's an incorrect statement to say I haven't looked at those others, because I even referenced it when I talked about stipulation, which interestingly enough, somebody put their own initials on the order for the stipulation for Department 13, rather than the judge's initials. But, so yes, I've looked at everything publicly available. I can't look at things that have not yet been filed. Yes, I looked at, in those publicly available stipulations, is why I made the statement about specific dates and scheduling, because, for example, if your one in front of Department 13 has the motion dismissed, not even filed until July 17th, the opposition August 30th, and the reply September 20th, but yet you're asking for a hearing date in front of this department. Well, right now it's September 6th. So that's why part of the reasoning for the courts needing that information and needing to have specific dates. Well, I appreciate that you needed the production, you want the production by the 15th in this case, which is the only case I'm currently discussing. The one in front of Department 31, I'll discuss potential cases in just a second. But is that you have language that says a reasonable time to take a 30B6. We all know, well, shall we say, sophisticated lawyers may have different interpretations what may be a reasonable time, right? And then there's dates triggered from said reasonable time, but we need hard and fast op date by X, reply date by Y. We need to have a schedule so we can get you taken care of in order to get you a hearing date that allows everyone to be fully prepared and no one's disadvantaged by not having the full preparation time, okay? So that's where we need to go for this case specifically, which is I'm gonna deal with first, okay? We're gonna reference the other two cases on the coordination, but we need to address this case first. If there's a disputed issue between hearing dates, remember this court cannot address a disputed issue on hearing dates on cases that are not before it. In fact, particularly, you have signed orders by two different judges, right? And they control their calendars on cases that are currently before them. So I can hypothetically discuss, you know what I mean, consolidation. You might decide that you want to do a stipulation under EDCR 7.50, maybe to talk about oral pronouncements from the bench today to be effective before they're memorialized in writing. But just remember, I have to parse this out separately because the procedural posture chose to file 3 separate cases. There are 3 separate departments. And so that all has to be respected and will be respected if and until the court makes a determination that maybe they're coming here. And remember the way, and that's what we're gonna have to walk through, is if they're coordinated, technically those case numbers do not come into this department, which will raise certain issues that we need to discuss what you're really intending, right? Because coordination, I will give you a hypothetical, I'm gonna let you speak in a second, I'm not sure, you may not be familiar, I was gonna give real water as an example, because there's some counsel who've been involved in real water, they're not real water cases to my knowledge. The real water case, they're informally called a series of cases that are in a variety of different departments, mostly business court departments, but some non-business court departments, some now have been, quote, consolidated later, but they were originally coordinated for discovery, which meant all the different trial judges did their own trials. There was trials in Department 16 was the first trial, Department 31 had the second trial, Department 15 had the third trial, right? So they did all their own motions, did all their own scheduling. Only thing was coordinated is there was a repository, similar to what's done with CD cases, is for documents, and in fact, there are some different parties in each of those cases. That was a coordinated case, multiple judges handling multiple aspects of it, depending on what was in the coordination order, okay? So Ewell's hybrid presents some challenges we have to walk through, because if you want the court to be scheduling trials, not saying that it'll ever go to trial, I appreciate that. I'm just talking about the current status for today. There's 3 cases in 3 different departments, right? Is unless those cases get bundled in so that everything's under Department 31, there are certain things that a court doesn't have the ability to control. So we're gonna walk through that in a minute. So that's what I'm saying, but I need to get, that's why I wanna focus first on the scheduling here in Department
Sure,
31.
and I'm happy to address the coordinating versus consolidating and update the court on what discussions we have had and how it ended up like this, and we're happy to go through those issues, but I didn't wanna jump the gun because I know you want to resolve scheduling issues.
Yeah, and that's why I kind of wanted a 2-step process, because remember I have to do what is currently in this department first, and then we'll walk through what your needs are for possibly adding more things to this department, okay? Which the court's going to be open to, but we just need to do it in accordance with the rules, okay? So, go ahead, Ms. Sneed, just so you had that heads up. I wasn't sure if you were familiar
Yes.
completely with the whole different interpretations of certain EDCR versus NRC provision and how it's actually applied in the 8th Judicial District. Welcome. Thank you. Go ahead.
Thank you, Your Honor, and that's very helpful for my understanding, and I appreciate that. I just wanted to say a couple of points in response to what Mr. Gayan has said about what has been going on. We have been in the process of meeting and conferring. We understand that there are not, solid dates based on, the stipulations that we put forward so far. I think just to clarify, Meta's position is that we have reached this stage in the case before Your Honor, where we've gone through jurisdictional discovery, we're looking at having the document production, we're going to have the deposition, and at that stage, we're going to have an opposition or reply in the hearing in this case. The other cases are not in that same circumstance. They're not nearly as far along.
We haven't even filed a motion yet.
Exactly. And so it was not our position that there needed to be any reason to wait until everything is in the same position for us to have a hearing, which is why what we'd like to do and what we propose doing is to go forward with the messenger case as it stands, with the record that we're going to develop in the coming month, based on the materials that are being provided as well as the deposition, so that the briefing schedule can go forward, and then we can have the hearing that we can address all the issues in the messenger case. And that will have an effect on the Facebook and Instagram cases. And we think it makes the most sense, given the work you're going to have had to do on the messenger case, for us to be able to come back to you for a hearing on the Facebook and Instagram motions to dismiss, rather than have these 3 different motions to dismiss hearings before different judges in the same jurisdiction. So that was the thinking behind why it's Meta's position that it makes sense to go forward in the way that we proposed time-wise. And we certainly can address Your Honor's concerns about identifying time.
We certainly need to, because we need to have concrete opposition and reply dates, folks. I mean, that's really the way it needs to be, right? We need to know when we're getting the things in order to be fully prepared. You need to know deadlines and when things need to be provided, right? So let's focus on that part first, okay? Whether or not there's going to, down the road, or even today, potentially be one or more than one hearing, will be a next step. Bless you. And you might decide that I still don't have counsel in the other case, right? I do not.
Your Honor, I think they had a calendaring issue. We had called them, and I think Ms. Buckwald was going to appear virtually, but I haven't seen her pop up yet.
No worries, it was 8:30. I just, if this case happened to need a break to discuss things outside and I could take your case, we were going to do that just for efficiency purposes. But since I don't even have all counsel in the gypsum case, then we're continuing with Meta. So, state of Nevada versus Meta. So, let's walk through what makes sense, because presumably from what I've heard so far, you all have not yet scheduled a deposition date for a 30B6 witness, and so quote, the reasonable time for it to be taken after the production has not yet occurred. Is that correct?
That is correct, Your Honor.
Have you identified the witness or witnesses, because we talked about yet, who are going to be deposed? Is that a yes or a no?
Yes, Your Honor. We have identified one of the potential 30B6 witnesses with the state in our I believe last week's meet and confer, where we were discussing this very issue, where we were talking about what would be happening next. And we had agreed to schedule a time where we were going to discuss, probably in the latter half of this week, the details about, timing for that witness's deposition, but we have not had that conversation as of yet.
Can you appreciate we need to know these dates, right, to get you a hearing date, right? Because I appreciate, remember, wonderful, fantastic senior judge who was covering, right, but doesn't have all the background. So your stipulation looks very nice on his face with a couple of type, right? But it doesn't have the conceptual aspect of what, as the presiding judge who's been here from the get-go on this case, that guess what, we need some concrete dates, right? And knowing that kind of history. So you all might have a proposal, but I can't give you a September 6th hearing date and then you all tell me that we're just gonna wait and see on when we're gonna do oppositions and replies, and you can appreciate why, right? I just said that a few moments ago. So can we today you're going to take the deposition of the 30B6 or 30B6s no later than X.
Yes,
You're going to
sir.
have an opposition by Y, and you're going to give a reply by Z, and I will get courtesy copies. And appropriately, please, DCR 2.27. I'm sorry I said that because I recently got 900 plus pages without any page numbers. And yes, we want to make sure we can get everything taken
I hope
care
that
of.
wasn't one of my cases.
It was not,
Okay.
otherwise I would not have mentioned it. That's why I would mention the person. Okay, I'm just saying, it's becoming more prevalent and you can appreciate, it's one thing when it's a few pages, it's another when people reference multi-hundred page documents and just say, see exhibits attached here too. Or you would just say, see pleadings in other case which we're adopting. And
Motion denied. That's how I would handle that.
as a well-reasoned jurist who ensures everyone's fully prepared, it just presents some challenges that presumably parties might want to make it so that the court can actually review everything if they want to have their arguments heard by a court. Now, of course, I will hear them. Of course, I still read everything. It's just I'm reminding people more because it's happening in the majority of my business court cases, which is somewhat of a surprise.
That sort of thing reminds me, I think it's in federal court cases, judges are not pigs hunting for troubles. You need to
Yes.
tell
Posner has
us,
a
tell us
very,
where you want us to look.
Posner's comment is very well taken,
Yes.
and I did cite that the other day. Okay, so let's get back to you all's case. I'm trying to give you a second in case you all had your co-counsels maybe thinking about dates, so I was kind of segueing for a second. Do you all need a moment to talk out in the hallways to walk through some of this?
Yes, Your Honor, I think that would be helpful. My next comment was going to be, we don't have a sense for the volume of the production on the 15th. And I was just discussing with Mr. Slade, you know, how much time would we need in a worst case scenario, and then what kind of a window for the depositions to happen. But I think it would probably be helpful, instead of just guessing, to go out in the hallway and talk to Mr. Sneed and his co-counsel and see
Because
if
on
we
July
can.
10th, presumably defendants aren't at step one of getting that production together. Presumably you're somewhat farther along. I'm not gonna ask you to say it right now.
No, well, I'll tell you this.
I'm gonna let you go
Your
back
Honor.
behind and speak with opposing counsel, but you can appreciate, you all want to know what dates things are due, so that you can tell whoever's going to be drafting it and researching it, right? Or maybe you already have certain things prepared, but it seems to me we can do that efficiently. How much time do you think you need? And I'll see if I can take the other case in the interim.
Thank you, Your Honor.
Thank you, Your Honor.
If I just say, keep your heads back in at 9 o'clock, does that work?
I think
Yes.
that's
If
more
you need
than
more
enough
time, just let my marshal know so that we can see if I can take my other case. Is that gonna work out okay, because I've got one counsel on both?
That's fine.
Works on great.
I'm fine.
You're good?
Yes.
We're back on pages 1 and 2, case 886110. We do not need you to make appearances again. We'll just say same parties, same counsel, unless somebody else needs to make an appearance that did not previously make an appearance. I'm understanding that's not the case, so we're going to move forward. Counsel for plaintiff and counsel for defense is standing up. Who's going to be speaking first?
Your Honor, I can handle that, and
And that would be counsel of state of Nevada. Thank you.
Michael Gayan for State of Nevada. I will note that Sydney Jing has also joined on Zoom, but we'll be observing only. I don't know that it's an appearance, but I just wanted to note
Sure,
that,
of course.
that she's there. After discussion with Mr. Sneed and his co-counsel, what we're hoping to accomplish in terms of the scheduling is to have the documents produced by the 17th. There may be,
17th,
or excuse me,
15th? Okay.
7/15, July 15th.
Okay.
Sorry, 17th is my daughter's birthday. Yeah.
Happy early birthday.
Thinking about that, yeah, sorry. So July 15th, we would get the document production. There may be a few supplemental productions that are discrete, but we've built that into the schedule as well to allow for that. And then the deposition or depositions to be completed by August 2nd, which would make the state's opposition brief due August 16th under the prior stipulation, and Meta's reply due September 6th under the prior stipulation. And then the parties, for a number of reasons I can explain if Your Honor would like to know, but our preference would be a hearing no sooner than September 20th, 2 weeks after the reply, just so we have a little margin for error in the schedule that I just recounted in case of document production issues or witness scheduling issues, because Mr. Sneed couldn't reach someone on the phone that he was hoping to reach. So we just want a little wiggle room in the schedule.
And how much time are you anticipating you will need for said hearing?
That's a great question, Your Honor. I'm sure you see it every single day of your life over here. Lawyers always underestimate what they actually
Oh,
need.
not these days. These days I get 2-hour requests for 15-minute matters. And then
okay.
they fill the time, but it doesn't
Well,
matter. What's a ballpark?
Let me think based on where we've been historically. I think we've covered a lot of ground on the jurisdictional issues, and we did argue at the preliminary injunction hearing, Section 230, First Amendment, and all these other things. So hopefully we can be a little more efficient with that. But I would think at least 90 minutes, maybe more. And so with all of the issues and the new discovery that's coming out, I would say 90 minutes to 2 hours. And Ms. Peterson suggested, and I agree, a special setting, if that's available, I think would be ideal.
Counsel for defense.
I might lean a little bit more toward the 2-hour time frame, but largely does sound reasonable. We hope that we'd be able to get through things in an efficient manner.
So here's what, no sooner than September 20th, correct?
Yes, Your Honor, please.
Okay. Here's what I'm gonna need to do, because sometimes there's a lot of things going on in the back chambers on scheduling while I'm here on the bench. I only have access to certain information, which people who may have gotten a step in another case may have realized we had to move something a day earlier because of,
I mentioned that in the hallway. So,
Yes.
yes,
So-
and that's why we thought the 13th might not be good anyways,
well, it's now the 12th at 1 PM,
right?
the signed order. I'm just saying, so to avoid that issue, I'm going to, as much as I would love to give you the information right now, we're gonna play it safe. And I'm going to coordinate with my whole team after the hearing, because I also got the 10 o'clock matter, and we're going to find a date. I'm going to tell you in advance, I'm not sure if people need accommodations, I'm aware there's certain things coming up shortly after that time period, so we'll make sure it's not on one of those dates to anticipate if anybody needs any accommodations, okay? Certain religious holidays are coming up shortly thereafter, so we will not book it on one of those. If there is a huge date, I already mentioned past your daughter's birthday, so we don't have that issue. If there is a huge date that you do not want it on, okay, or if maybe you happen to be familiar that somebody in light of moving something else is now going to ask me because there's a couple of other things that they're going to ask for a different date. Please enlighten the court so that as
Your Honor,
much as my JEA loves spending hours and hours rescheduling things as people send us letters and then say, guess what, oops, that date really wasn't good. You can appreciate we always try and get as much information as possible so we can accommodate all the cases on our docket.
Your Honor, although your JEA is fantastic, we do not
She
want
loves
to
to
take
hear that.
any more of her time than necessary. Maybe one suggestion I have is if you want to check with your team and your JEA could email the parties or issue something with a few dates that the court is available, because on Hilton and that discussion, I know you are very
Other
busy.
cases,
Other cases, you are recent discussions on scheduling.
that was a
you conveyed-
2 hour, that was a 2 hour
Yes, you're very,
scheduling conference.
you're very busy, is my recollection and what I conveyed in the hallway just now.
That
So-
one wasn't, that was a variety of councils coming up with a variety of their own schedules, which
a
we're
lot of
really
issues.
glad to try and accommodate. But we just would prefer to hear them before, so we're not, because I have
Sure.
other cases on the docket that probably would not like to wait while people are determining their own schedules. So here's what we're gonna do.
Okay.
Why don't you give us a letter by mid-next week? That gives you a chance, because you need to talk with your witnesses, right?
Yes, and certainly Mr. Hester, as I'm sure he would wish to be able to be here today, he would certainly need to be in attendance, and I have been able to talk to him
I
about his schedule.
presume there might be some behind the scenes that people would prefer to take care of, so I think probably both sides, please let me know if I'm incorrect, would prefer if I just say get a letter within, today's Wednesday, by next Wednesday, right, of 5 proposed dates, okay? If one of those dates work from us, we will do it. If they don't, we may need to reach out with you with some other dates, but that way you all can see where you're at. Please do not pick, like I said, well, we're gonna accommodate upcoming things, and if there's something else that needs to be
We
taken
will
care of.
avoid religious holidays.
And if you're aware of another case that has a large amount of time, since several of you are on some of those other very large cases, more than glad to do them on the same day, but you know what I mean,
We will avoid those types of things as well, Your Honor. One question,
Mondays and Fridays are gonna be your best shot.
Mondays and Fridays? Okay, great. And is the court inclined to set a special setting?
Oh, yeah, I'm gonna give
And
you,
if so, is it morning or afternoon on a Monday or Friday where that would fit?
hold on just 1 second, give me a quick second. Okay, the trial starts October 13th. I'm going to tell you, I know there's a couple of days that are bad, and this is not an exhaustive list because once again, I've only multiple calendars handling multiple different issues, so. September 20th, I'm currently aware of. Please do not pick September 25th through 27th. For religious accommodation issues, please don't pick October 3rd, 4th, or 10th, or 11th. Okay, that's what I currently show. If somebody has a longer time period that they need an accommodation, that's perfectly fine. That's just ones that I currently know about. So those are some dates that I know are not good. Those are, and so that gives you late September, first couple of weeks of October, which is where I'm presuming you're gonna wanna have that, right? Is that the ballpark time period you're gonna want?
I think so, Your Honor, sometime between probably September 23rd and October 4th or so, noting the blackout dates that you mentioned.
Right. And that works because my trial that was supposed to be September 30th is no longer. And my current knowledge, and once again, back to some of your cases, got some multi-day preliminary injunctions, some other things that are also pending dates. If you wanted some hypothetical dates, what it looks like is Monday the 30th, Monday, October 7th. I might have availability morning or afternoon to answer the question that you were asking, morning or afternoon, because it's a Monday. It looks like, hold on, let me go to a different calendar. And like I said, these are hypotheticals because these are clerk's offices putting things on all the time while I'm talking. So October 2nd, it looks like I could probably do 9:30 or 10 o'clock on October 2nd or October 9th. That's where I can quickly glean. Like I said, don't hold the court to those because I don't know
Sure.
the clerks right now, 5 minutes later, they might pop on a injunction hearing that they don't yet know about. So
Okay,
if
well,
that
Your
gives you a
Honor,
ballpark of 4 dates in your scheduling, which kind of should meet your needs.
we will work with Meta's counsel and get Your Honor some available dates, factoring in the information you just provided, and we could probably get it to you sooner than next Wednesday.
I tried to give you some Mondays, realizing people are coming from out of town, if that's easier, but also midweek, if midweek is easier, because there's the people that like to do things midweek because they like to spend their weekends with families and don't want to necessarily be traveling on the weekend. So I tried to give you beginning of the weeks and midweeks. Go ahead,
Very
Councilman.
kind, Your
I
Honor.
had a housekeeping question, Your Honor.
Sure.
We've set forth our agreement on the briefing schedule. Obviously, there's an order that's been signed by another judge while you're out of town, setting a hearing date. Do you need us to submit another stipulation? Should we simply wait for the approved date first? And how do you want to
The
handle
reason why I
that?
gave, thank you, that's the reason why I gave you the deadline I gave you, is because we're gonna do a modified order,
Okay,
right? And we're gonna do a modified order, setting a notice of hearing with, now we can do it 2 ways. One, you can give this court a stipend order that after today's hearing, right? You've already agreed that production is by X, deposition is gonna take place by Y, or I guess I can't, X, Y, Z, you don't have to do double A, right? Opposition by Z and double A for the reply, and then leave a blank for the hearing date, and we can fill that in when you submit it, next week. If you want more clarity right now, okay? If you're comfortable that you're gonna do the letter and then we get you a date, once again, if you send that kind of close to the time you send the date, then we can fill in the date. If you've given us some proposed dates, and I've already given you some options, okay? So we can get that all done. So that's all gonna be done before September 6th, but I'm not gonna vacate this. Administratively, it's easier for our clerks if we keep a solid date and then it gets moved to a new solid date
okay.
rather than just vacating it and getting it taken care of. That's generally, right, it's easier to move it than a set date, right? Okay, that's,
And Your Honor, for the
does that
sake,
answer, just a second, let me make sure I've answered.
yeah,
Counsel, does that answer your question?
Yes, it did.
So it gives you a way to get it done, get what you want. Go ahead, Counsel, Lane.
Your Honor, on behalf of the state, Michael Gayan, I'm comfortable with option number 2. We've stated on the record here today what the briefing schedule will be. We'll wait, we'll have a hearing date, and then if we need to submit a new stipulation or whatever with the full schedule and the hearing date, we can do that.
Right, most people like to have a seat, how they, you know what I mean? Because you're sending things to clients and you're sending things to other councils who may or may not be present today. I get that, but that part can work. Now let's go to part 2 of your hearing, right? Part 2 of the hearing is the current cases before Department 15 and Department 13. Okay, so as the court noted, conceptually, the court's fine with the concept, but the court can't do dispositive motions if those cases are not actually before the court, right? So the court can't do motions to dismiss unless those actual case numbers are all in this department, okay? That's not, because that's a dispositive motion. And while you can say, guess what, the plain language of each of those rules doesn't specifically preclude it, right? It does preclude it because it has to be something short of trial, right? Short of trial is a resolution of the case, so that means a dispositive motion, right? Because I don't have the authority to take away, not my best legalese, but to take away somebody else's case, right? To rule on a dispositive motion standalone. If I were to give you a parallel, if you take a parallel with arbitration matters, right? The exception on arbitration matters is motions for summary judgment, dispositive motions come before the trial judge, they don't become, we have court annexed arbitration. So an arbitrator can do most everything, but if it's a dispositive motion, it has to come before the actual judge because it's their case number. So we have case numbers that are assigned to judges. So unless the case number comes to this department, I can't rule unless you think that you have a different opinion, I'm gonna need a brief on it.
No, Your Honor, look,
I mean,
I'm
but you understand the concept, so.
we do understand all of that. We've
Can I
had-
stop you for a second? Because
Sure,
there's a
sorry.
potential idea. What you may be asking the court for is consolidation with a right to argue bifurcation, is what you may be asking this court for. If that's what you're asking the court for, that is a possibility, because then the cases, numbers all come to this department. This court can rule on dispositive motions. If you reserve your right to bifurcate, whether it's a claim or whether it's a party for certain purposes, then you have the bifurcation rules. Of course, not providing any legal advice, just when I was reading through this, since you phrase it as consolidation/coordination, it appeared to me that maybe you were saying consolidation with bifurcation options. Now, I'm not sure if that's exactly where you're going, but I'm just saying I could see a road to that. What were the parties asking the court to do? Go ahead, please.
Thank you, Your Honor. Michael Gayan for the state. We did discuss all of these things. Even in the meeting before, I mentioned exactly what you described for real water on the coordination and what we are hoping to accomplish here and tried to articulate in the stipulation of proposed order is to consolidate for less than all purposes, but we want all three cases assigned to Department 31 for a number of reasons. Judicial economy, to avoid inconsistent rulings, to have, and I know Ms. Peterson will never agree to this, but a single special master over all the discovery issues and those sorts of things. So we want, for efficiency's sake, consistency's sake, Your Honor, to preside over all three cases in a consolidated fashion, I believe is the appropriate term, but for less than all purposes. So for everything short of trial, with the parties reserving their right to argue either a combined trial or separate trials. And that's in paragraph 14 of what we submitted, that we want all the trials to be before Department 31, but each side reserves their rights and arguments on to later argue they should either be tried together or separately. And we're
That's not
not,
what your order says. Okay, take a look at page 6. Not only is that not what your caption says, but if you look at page 6, the actual order, you want them coordinated. That's the reason why the court is clarifying
And
what
that may have
the
been
intent was.
Your Honor, I can say, that may have not been updated. I did have a comment on here on the draft saying update the order to be consistent with the STIP. Maybe I didn't look at that and make sure that happened. But the idea is, I think the wording of EDCR 2.50 and NRCP 42, we would like consolidated for less than all purposes, and the only thing less is trial at this point, with the parties to reserve their rights to argue later under Rule 42 how the case should be tried, whether it should be together or not, and maybe that's a trial protocol briefing or something like that later, but we do not want them consolidated with a single trial date at this point.
Okay, so is it a single trial date, not a single trial department? Is that what you're going for? Meaning you want to have a single trial department, but you may not want to have a single trial date.
That's
Which is
exactly
the
right.
bifurcation component.
That's exactly right.
Okay.
We want all three cases, Your Honor, to preside over, or Department 31, whoever is in Department 31 for the duration of these cases, to preside over all three cases from beginning to end, with the only caveat at this point, no party is agreeing to have a joint trial on all three matters. That's all.
Then you can appreciate the order, not only your caption, but the order has to be consistent therewith. Counsel for defense, are you concurring with what counsel for plaintiff said, even though you'll have a disagreement with regards to A, whether there's a need for all of this, B, whether there's a need for one or multiple special masters, current term utilized by the courts, not a term that I pick, but that's the current term. And C, for all parties to be able to argue if, depending on what the process is at any particular time, that things should be bifurcated out, either by claim, by full trial, et cetera.
I largely agree with everything that my colleague said, and yes, thank you for those reservations. I did just want to flag, we actually did
Did I miss
mention,
one of your reservations? Go ahead.
no, but I wanted to mention, the stipulation actually said that no, I'm not agreeing to it right now, but we have already conceptually talked about the idea of a special
Special,
master. Yeah, so I just wanted to make sure that that was clear. But at any rate, yes, Your Honor, I agree with that. And it sounds like the best thing to do would be for the court to reject our current stipulation. We will revise it so that the order is more in line with a consolidation with, of the three cases, with the ability to seek bifurcation at a later time. But I think substantively,
Oh, okay.
yeah.
I'm gonna let you, let me let them finish their conversation. Go ahead.
Yeah, I've lost my train of thought, Your Honor, but I do think that we can revise this. But conceptually, our agreement, as stated forth in the stipulation, is what we're trying to do. So I understand the court's concerns, and no, we're not trying to have three different cases in three different departments. We're trying to have them all here. So I think that was a misapprehension of language in our end.
And Your Honor, I agree with Ms. Peterson. I think the parties should go back and rework this. We will not use the word coordinate at all anywhere in the stipulation or the order. We will focus on exactly what we've talked about here and make it crystal clear, and then resubmit for the court's consideration.
Here's what the court has to ask you all a question. And this is more on the clerk side of things, master calendaring clerk, not courtroom clerk, so I'm not gonna put my wonderful clerk. And we have a wonderful new clerk also coming in for some learning purposes. See how wonderful, gets to learn all this stuff. See, we promised you detailed, complex things. I will give you an example. From what you all are saying, I need to have a better understanding. Do you wish to retain 3 case numbers or 1 case number with the subordinated cases? Now, for your purposes, you may not see a distinction, so do you want the reason why I'm asking that, and I can clarify for a moment, because sometimes people don't understand what that distinction is. Oftentimes when cases are consolidated, I'll make an easy example, I'm not giving any legal advice, take 2 automobile collision cases, right? Maybe someone gets an automobile collision day 1 and then gets another one on day 2, right? So it has most of the same factors, but most of the same injuries. Those get consolidated under the lower case number. The subordinated case only shows up as a subordinated case. So everything gets filed in the first case number, and it doesn't maintain its separate identity as a subordinated case. In fact, sometimes when we close a case, we don't even remember to close the subordinated case, but that's not you all's issue. Okay. There may be a process, and I need to coordinate because sometimes things have changed depending on administration, which is outside of the department control. is that if the cases are transferred to this department for coordination purposes, we might be able to, and I have to check, to keep 3 case numbers if the case number issue is of importance to you versus one being treated as a main case and subordinated case, okay? From this court's position, if you file a motion that you want things bifurcated, I'm gonna do it by claim or however you've done it, right? Okay, if it's a stipulation, I'll deal with it that way. But if for some reason you all need it for whatever your purposes are, that you need to maintain distinct case numbers, please let the court know. And if it's not an answer you can give me today, we can find out on our end, and you can add that to your letter with your proposed dates for next week. That, you know what I mean, if, you can put some language in, if possible, we would like to maintain the case numbers. If that means we need to transfer and consolidate, then we wish to do so. Or you're fine with it being treated as a subordinate case, okay? So maybe you have no preference. So is that something you want to evaluate? Go ahead, please.
Yeah, Your Honor, Michael Gayan for the state. I'm prepared to address that today, and I'm really glad you brought that up. I did notice when you pointed out the order didn't line up with the stipulation. Also, the order mentions this master docket concept that I deleted from the stipulation, and I wanted to talk to Your Honor about it before we got there. Personally, in my experience, I don't know that I want a master docket where everything in all 3 cases gets filed in the same case number, because especially since we're not agreeing to a single trial, we could conceptually have Rule 56 motions in limine, and how do you know which case they relate to? It might get complicated. I could see having a combined caption, and you say that this filing relates to whatever case, but I did want to talk to the court about its preference on how to address that. I think there's value in maintaining distinct case numbers still, because I could see motion practice that's discrete to each case potentially. A lot of the discovery work, if we get to that point in the case, and I understand there's motions to dismiss that are either filed or will be filed, but if we get to that point, I could see a lot of that being overlapping and maybe a single filing, and I imagine Meta and the state would want that to be not redundant between the 3 cases to the extent possible. But I could see times when distinct discovery issues could come up between the 3 cases as well. And an objection might come up to Your Honor, and it would be good to know which case and platform does this issue and motion relate to, and not trying to have to sort it out on the document, or on the docket. You look and you have your docket number 243, well, what does that relate to? How do I know? So I could just see some confusion if we lump them together, and I believe there's value in keeping them distinct, but I certainly want the court's input on, because you have more experience managing these types of cases than I do, because that's all you do. And you have a lot more cases than I do. So I certainly would value the court's input and preference on that, and I'd also like to hear from Meta's counsel, but I think there is value in keeping them distinct at this point.
I would agree that there's value in keeping case numbers distinct. So the next question is really how to effectuate that.
I need to know if it can be effectuated. I need to check with the appropriate, and to answer counsel for plaintiffs kind of questions on a statement. The way it's been done in the past, it's been bundled, and I look through 900 or 1,000 type entries and try and find something discrete. You saw that in real water, you saw it in opioid, and I can give lots of examples. DOT, okay, so.
Doesn't sound fun.
It's part of my job, okay, but if it's, so this request has never been made to this court that I can think of in the last 14 years. However, as a proactive approach, if it's something you're interested, I can see if it's possible, okay? I might be told it's not possible, and then we may have to have a plan B, which the plan B is kind of what counsel for plaintiffs discussed, is that on the caption, you still have to put this, and then, you know, you put the case numbers, and then you say, this motion applies to case number blank, okay? So there's a plan B for it, but let me see.
Is the idea of the combined caption on our draft, or on the stipulation we submitted, is that consistent with how the court would like things?
Once again, it's going to depend if it gets consolidated, okay, the standard consolidation is parties put the main case number, and then usually they put below it consolidated with blank, okay? And the advantage usually for parties, right, for consolidation, for filing purposes, is unlike what you had to do in real water, for example, is in real water, you had to file it in the department that your issue was, and then you also had to file it in the coordinating department, i.e. that was Department 27, right, so that, and then there were certain things that got filed in multiple departments, okay? So the idea of consolidation is also for the parties' purposes, is that you just file it once, boom, it's there, and the court can deal with it. But what you're really asking is a little bit more of a hybrid, okay? It's the kind of issues that really come up generally closer to trial. The fact you're doing it now is great, it's proactive, okay? But, so on a standard consolidation, one case number, and then you figure out what it's for. And we usually deal with that from a caption standpoint. But your nice proactive aspect of already saying that you are going to want some distinct, subject to rulings that are not yet made by the court, particularly on pleadings that have not even been filed with the court, and certain things that aren't even before the court yet because they're in different departments. So not making any advanced rulings on any of those things that aren't ripe. But I can see if there is an ability to do what you may be asking for, okay? The answer may be that it's not feasible because sometimes you can appreciate doing something unique for one case when there's thousands and thousands and thousands of cases, right? May not be possible from their software standpoint. I just never been asked, so never had to deal with the issue yet, okay? But here, let's find out if it, I wasn't gonna look into it if it didn't meet your needs, right? If you're saying it potentially meets your needs, let me see if there is some possibility.
Doesn't hurt to ask, and I think we're interested in what Ms. Peterson and I described, and whatever is administratively possible, feasible, and easiest for the court. We certainly don't want to take any more of the court's time or your fantastic JDA's time trying to ferret out what case a certain filing relates to in a master docket that's 1,000 entries long.
The concept is, if I can, is really where kind of thinking, if it works out, is if they treat it like a, maybe more information than you may not want to know, or maybe you do want to know. Let's take it when a judge retires, right? Or dockets, or sometimes, right? Your case has been transferred from a department X to a department Y, right? So that whole case gets transferred to the new department, but all your filings move with it. I'm gonna potentially try and see if you can keep your 3 distinct case numbers. It just has a Department 31 numbering on it. And so that if you're filing, if you want it to be filed in both the Instagram and the Facebook case, then you have to file it twice, right? Because they will have distinct numbers.
We will do whatever is.
But is that what you're gonna wanna do? Are you gonna want to do it that way when you're filing?
I think the preference would be to file it one time, and if we identify that it relates to all cases, then we file it in the lowest number case, which is this one that you have now. If it relates to only one of the 2 subsequent.
That can't happen. And the
Okay.
reason why that can't happen, let's take it, if you maintain separate case numbers, then it will only be populated with the case number that you file into. And I appreciate probably none of you would do your own filing, but okay, whoever does your filing on your behalf, right, has to type in a case number.
Sure.
And has to type in a code for what type of pleading it is. That's one of the advantages of consolidation from an attorney standpoint, that's why we have a lead and a subordinate case. You only have to file in the lead case, right, and everything populates into addressing that. It has the disadvantage of, yes, you can have 900 entries, and you have to find out if that one really relates to which part of a case, particularly when, like I just did a 7-part consolidation that finally got resolved. But it can't be, if they maintain separate case numbers, you will have to do separate filings because of the fact it won't populate in more than one case number. Can you imagine?
Sure.
That would be a full-time clerk dedicated to try and figure that
So-
one out.
Just so I'm clear about
Sure.
the filing issues, if, for instance, we were filing in a motion to dismiss, or let's say a reply brief in a Facebook case, and the cases were all consolidated, what you're saying is that motion to dismiss, since it only applies to the Facebook case, and you would only be filed in that case number, not in this one, or we file in both.
That's, okay.
But that's not, and I'm only asking you, that's not been my experience with other consolidated cases, so maybe they're all
But
managed
that, but you're saying,
wrong.
that's
I
what I'm
don't
saying,
know.
distinction between, that's why I said what you may be asking is something new. It's a transfer and maintaining case
I
numbers.
see.
Your experience is exactly what happens in consolidation. You don't have to file it multiple times. And if you're asking for something unique to keep these distinct with case numbers, then it comes with it, most likely. It's two additional cases transferred to this department, but you then would have to file things case number specific, and they get hearings case number specific. And if it was on more than one case, it'd have to be filed in both cases. Do you see what I'm saying?
Okay.
Yeah,
Which is
and-
why many people like consolidation, because you don't have to do the very thing.
Right.
If you were to take the opioid case you were involved in, or the real water case your firm you involved in, right? If you all had to file every single part, you know what I mean? Those opioid cases had a large number of the DOT cases, right?
Or in-rate high-tech, they were consolidated, renamed in-rate high-tech, and everybody just filed in the lead case, and that was it. And,
So
yeah,
you may be saying, in light of what you're now walking through, which is why I'm fine if you want to wait till you do the letters so everyone can coordinate with who you need to coordinate with, is you may be saying, we really are going to prefer the caption alternative issue, right? That they're consolidated, but you put in the caption, motion to dismiss in blank, okay? You can put Facebook case number, right? Put it in parens, only, what filed in the lead case. But this applies only to what was previously case number blank, so you could deal with it from a caption standpoint. Do you see what I'm saying?
yeah, why don't
Versus
we
a
meet
final.
and confer on
That's what I
that,
thought
and
you might
maybe we
wanna
can
do.
defer this issue, we'll get through the scheduling issue, we'll fix the coordination versus consolidation and the stipulation submitted. And it sounds like,
Let's stop you for 1 second, because why I'm interrupting you is because I do need to know which way you potentially want it first off,
okay,
because I can't sign the order
Right.
on consolidation unless I say it's, because it would be treated as a standard consolidation. If you're asking for something special, I need to know that because it has to be part of the stipulation. So it has to be a couple step process. I will check with the clerk's office, to see if it's even a possibility. We can do that probably by Monday, okay? We hope to get an answer because I can't tell you what their schedule's like, okay? You don't owe me a letter till next Wednesday or Thursday, right? So then you'll get a response back if it's even possible, then you all can evaluate in the interim whether you want it anyway. You put it in your letter, you send me the new stipulation, right? We address it then so that it's all taken care of one fell swoop because it can't go back and forth. You see what I'm saying?
that sounds
It's a couple
perfect,
step
Your Honor.
process.
That would be fantastic if we had that information on what's possible, and then we can meet and confer on what we need. We'll either put it in the letter or the revised stipulation order or both, and the court will know what the parties would like.
Does anyone have any questions on kind of what we went through on potentiality? Everyone's good, everyone's clear on it?
All good for the state, Your Honor.
I think we're good, Your Honor.
Okay. Any other matters that the court can address today? Because what we've done today is we've gotten you your briefing schedule in the case currently before Department 31. I am going to have to review the proposed stipulation to decide whether the court can sign the consolidation stipulation. I am telling you my inclination is that I am going to do so, but I need to see the actual language because I can't sign off on something until I see what you're asking me to sign off on. But my inclination is what's been represented in open court is going to be amenable with the small caveat on a consolidation/transfer process, okay? So I think that gives you some clarity there. And we've got deadlines for the case currently before us. Is there anything else anybody needs?
Not on behalf of the state, Your Honor. Appreciate the court's time, as always.
Nothing else, Your Honor. In terms of notification to us about what you can learn,
My JEA will send an email,
perfect.
Well,
That's
e-serve it to the parties, so whoever's on your e-service list will get it, okay? That way
Thank you.
there's no ex-party communication, that way you're getting the same information, everyone's getting it at the same time.
that's perfect, Your Honor.
That
Thank
work for you? Okay. That work for you, counsel for the state?
Yes, Your Honor. Thank you very
Okay.
much.
And please check with your respective firms in case any dates you told me today, somebody's not asking me for that exact same time, because we try and make sure everyone is fully taken care of, so
We appreciate the courtesy and patience.
no worries, it's all good. Have a great one, everyone.